House will come back to order. I'm going to ask the clerk to ring the bell. Okay. We'll do the best we can.
Okay, thank you, sir.
Where's Anna? Sergeant. Clerk will read the caption to a group of privileged resolutions. The clerk will read.
Resolution by Representative Beasley Teague, 65th, recognizing commending Yvonne T. Robinson on significant achievements. Resolution by Representative Coleman, 97th, recognizing commending junior leagues, Georgia State Public Affairs Committee. Resolution by Representative Nix, 69th, honoring life and memory, Mr. Walter Johnson Lucan. Resolution by Representative Coomer, the 14th, recognizing commending Yanmar America Corporation for its superior efforts during a natural disaster. Resolution by Representative Coleman, 97th, recognizing commending James Randolph Sandlin. And a group of resolutions by Representative Coleman, 97th, recognizing commending Eagle Scouts, Boy Scouts of America. And a group of resolutions by Representative Dickerson, the 13th, 113th, recognizing commending Thomas Hanson III, and other Eagle Scouts, the Boy Scouts of America through the privileged resolutions.
Is there objection to the adoption of the privileged resolutions? The chair hears none, and the resolutions are adopted. Clerk will read the caption to House Bill 94. House Bill 94.
House Bill 94 by Representative Welch of the 110th. The bill to be entitled Act Amendment Title 51 relating to general provisions for damages so as to change provisions relating to the reduction of earnings to present value to provide for determining the present value of certain future damages and related matters. This bill having been for the House Committee on Judiciary, the committee recommends the bill pass by committee substitute. Bills being read today for the third time.
Chair recognizes Representative Welch to present the bill. Representative Welch.
Yeah. Thank you, Mr. Speaker. Members of the House, I have before you House Bill 94. I ask for your favorable consideration of the bill. This is simply creating greater flexibility for juries and triers of fact in personal injury cases where the litigation is ongoing and there's a determination of the present value of damages. Current law has a mandatory 5% reduction in value of present damages. This actually would allow that 5%, but it also allows, or any other discount rate, the trier of fact may deem appropriate. Furthermore, in Section B of the bill, it precludes the use in evidence any kinds of products that might be used for calculating what the further value of the damages could be over the time of the claim. I'd be happy to take any questions.
You do not have any questions.
Thank you, Mr. Speaker.
And gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 94 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 94. The ayes are 167. The nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 207. House Bill 207.
House Bill 207 by Representative Shaw, the 176th bill being entitled Act Amendment Title 27, relating to licenses, permits, stamps for hunting, trapping, or fishing, to provide definitions to authorize issuance of a special turkey hunting permit for young and mobility impaired hunters, to amend Code Section 27.315 relating to seasons and bag limits for wildlife, so as to provide an extended turkey season for young and mobility impaired hunters. Bill has been for the House Committee, Game, Fish, and Parks. The committee recommends the bill to pass by way of a committee substitute. Bill's being read today for the third time.
Chair recognizes Representative Shaw to present the bill. Representative Shaw.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, today I bring you a substitute to House Bill 207. This bill deals with the laws and regulations dealing with our turkey hunting season in Georgia. And what this bill will do is encourage those that children under the age of 16 and folks that are permanently disabled as defined in the bill. It'll allow those individuals to go out in the turkey woods 1 week early on the weekend before the normal season starts on a Saturday and Sunday for 2 days, and allow them a better opportunity to achieve success and enjoyment in the woods for those that need it most. The definition of disability in the bill is very tight to make sure that it's limited to those that truly can't hunt on their own. And the underage, the 16 and under, is the same we're already using for deer hunting laws, with a special season for those. The substitute version, the change involved in the substitute was a compromise that will still allow the DNR board and the commissioner to promulgate the rules just like they do the other hunting regulations, and allow the biology and the public input to be a part of the regulation, so it would have to be reauthorized each and every year. So we're enabling this to happen so that these youth and the disabled can go out and enjoy this special season, but allowing the DNR board to have the final say. And I just want to say that I've got some dear friends at home that take a lot of time out of their own hunting schedule to take folks just like that are defined in the bill hunting, and I haven't actually had the chance to go with them, but I can't imagine the enjoyment that somebody could get by taking someone out in the turkey woods and having success. For someone that just couldn't do it on their own, I think that's what this bill is intended to do. And I'd appreciate your favorable consideration, and I'll be glad to answer any questions if there are any, Mr. Speaker.
Don't have any questions.
Well, thank you, Mr. Speaker.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 207 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 207. The ayes are 166, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 256. House Bill 256.
House Bill 256, Representative Harbin, 122nd, a bill to be entitled Item Title 16 relating to sale or distribution to or possession by minors of cigarettes and tobacco-related objects so as to provide definitions, provide for the regulation of cigar wraps. The bill having been for the House Committee on Juvenile Justice, the committee recommends the bill do pass. Bill's being read today for the third time.
Chair recognizes Representative Harbin to present the bill. Representative Harbin.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, House Bill 256 is very simply just defines cigar wraps in the code and then adds those cigar wraps to tobacco products so that they cannot be purchased by minors in this state. I will yield for questions. If there are no questions, Mr. Speaker, I ask for favorable consideration of House Bill 256.
You have no questions. Gentleman has yielded the well. Is there any objection to the previous question being ordered on House Bill 256? Chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 256 will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 256. The ayes are 166, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 268. House Bill 268.
House Bill 268, by Representative Hardin, the 148th, the bill to be entitled 2 relating to dealers in agricultural products generally, so as to remove cotton and eggs from the definition of agricultural products, to establish a fee for licensing of dealers in agricultural products, to modify bond requirements for dealers in agricultural products, to amend Title 2 relating to grain dealers, so as to expand the definition of grain, to modify bond requirements for grain dealers. Bill having been for the House Committee on Agriculture, Consumer Affairs. The committee recommends the bill do pass by committee substitute. Bill's being read for the third time.
Chair recognizes Representative Hardin to present the bill. Representative Hardin.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, this bill is basically been called a lot of things in the process of vetting it, and it has been thoroughly vetted. Basically, the problem existed that we are operating under some outdated laws in the Agriculture Department. Commissioner Black, when he came on board in 2011, decided to let's update our laws to really mirror what's happening in the agricultural community. Chairman McCall and Chairman Bullock met over the summer with the Agriculture Department, with industry leaders, with dealers, with everyone involved
in the marketing plan of the agricultural products in our state. These are the changes they've come up with to allow us to go forward in a manner that gives some protection to our agricultural producers and also creates a good system for those who would purchase those products. Eggs were removed from the agricultural products because though the egg producers and the egg marketing plan basically is operating well as it is and is not needed in this particular plan. The major change now is that on line 43, you'll note that the department was supposed to issue licenses to those purchasing agricultural products or who were dealers, but it said no fee for such license shall be charged. Well, unfortunately, that meant that it was pretty well ignored. We found that in Georgia, we had 264 licensed agricultural dealers. Florida, by comparison, has 3,100. And so what this does is to establish a license fee, as there is with any other business in this state. And it can go up to $400, but that is up to. And it depends on the size of the business and the products that are being traded. And then there's been a lot of questions about the bonds in this and how the bonding system works. But if you'll note on line 57, it does say the bond shall be equal to the maximum amount of products purchased or sold for Georgia producers or estimated to be purchased or sold in any 1 month by the applicant, so that the numbers that we see in here for bonds are maximum numbers that a dealer must have. A smaller dealer would have a lesser bond, so that it's not really a problem to any dealer to be bonded and to ensure that he can, in fact, meet the requirements of purchase of the agricultural products. And if we go on through now with there is an exception on line 62. Under pecans, the bond goes to $500,000. This is simply to mirror the economic conditions of that market now, and the fact that many dealers may in fact purchase far in excess of that amount per month from a producer. So that's the reason for that. On line 73, we see that there's been added to the if a license is canceled, then a person shall be ineligible to reapply for license for a period of 4 years after revocation. That is to ensure that the people that we have in this system who are purchasing the agricultural products are trustworthy and will be bonded and can meet their obligations. Now, as we were vetting the bill, and you noticed in the caption it said that cotton would have been released from this as eggs were, we found that there was a problem with that. But we also find that in the cotton marketing chain, it looked as if maybe a cotton gin might be required to have multiple licenses because of the way the purchasing goes in that particular chain. So that is the reason for the addition of line 87 and 88. No warehouse that is in full compliance with the provision of Article 1 of Chapter 4, Title 10 shall be required to obtain a license or maintain a surety bond under this article. There is a United States Warehouse Act, and that act does require cotton producers to be bonded, and so if they're bonded there, then they would not be covered under this act. The definition of grain was changed. When this law was written, those grains listed were probably the only things known. As you know, agriculture has progressed, and we have other products, so therefore that was added, not limited to. And then under the grain section also, the bonding was raised from the maximum bond, and let me stress again, these bonds don't mean you have to have that big a bond if you're in the business. You only have to have a bond that will cover 1 month of purchases of agricultural products. I feel that all of these are good changes. It brings our law up to date with the current agricultural marketing plan. And ladies and gentlemen of the House, we need these changes to protect our producers of the largest industry in the state of Georgia, that being agriculture. Mr. Speaker, if there are any questions, I'll be glad to answer.
You have a question if you yield.
I yield.
Chair recognizes Chairman McCall to your right for a question.
Thank you, Mr. Speaker. Gentleman, yield.
I yield.
Is it not true that this language that we have in front of us is a result of a lot of work from the first of the session to correct a law that's been on the books since, some of it since the 40s, and this is a result of bringing it into modern times to take care of the people that produce the food and fiber in this state?
That is exactly right, Mr. Chairman, and we appreciate so much yours and Chairman Bullock's efforts in seeing that this was brought into the real world of agricultural marketing.
One more question, please, sir.
I yield.
There's been some question about the $400 fee. Is it not true that it is on a sliding scale and $400 is just a cap? It's based on how much you buy, and it reduces down.
That is correct, and these are up to amounts, and not that's the maximum amounts that would be required.
You have no further questions.
Thank you, ladies and gentlemen of the House. I ask for your favorable consideration of this bill.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 268 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 268. The ayes are 167, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 332. House Bill 332.
House Bill 332 by Representative Williamson, 115th. Bill being entitled Act entitled 43 relating to nurses, so as to reconstitute the Georgia Board of Nursing, to provide for membership, appointment of members to define a term, to repeal the Georgia Board of Examiners of Licensed Practical Nurses. Bill having been for the House Committee on Health and Human Services, the committee recommends bill passed by committee substitute. Bill is being read today for its third time.
Chair recognizes Representative Williamson to present the bill. Representative Williamson.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring today for your consideration the Health and Human Services Committee substitute to House Bill 332. Georgia is only one of 4 states in the nation that do not have a combined board of nursing, and today I bring this bill at the request of the Georgia Board of Examiners of Licensed Practical Nurses and the Georgia Board of Nursing. Both boards voted unanimously to combine into one Board of Nursing. Ladies and gentlemen, this will give the state of Georgia more effective, efficient services to our nursing professionals throughout the state. It will reduce the expense of government for administering this, and so with that, it's just as simple as that. I'd be happy to answer any questions you might have on this bill.
You have no questions.
Thank you. I yield the well.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 332 will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 332. The ayes are 166, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 337. House Bill 337.
House Bill 337 by Representative Fleming, 121st. A bill to be entitled Act to amend Title 20 relating to student health in elementary and secondary education so as to authorize public and private schools to stock a supply of auto-injectable epinephrine, to provide for definitions, provide for requirements and reporting, provide for arrangements with manufacturers. Bill having been for the House Committee on Education. Committee recommends the bill do pass. Bill is being read today for the third time.
Chair recognizes Representative Fleming to present the bill. Representative Fleming.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring to you today House Bill 337 for your consideration. Ladies and gentlemen, a couple of years back actually, this House did some good work in expanding the ability for our schools to have on hand epinephrine pens, the emergency shots for kids that go into anaphylactic shock after, say, a food allergy or a bee sting. This bill takes that one step further by saying that the school can have on hand these shots in case some student who they did not know has an allergy encounters one of these emergency situations. It simply changes Georgia law to allow a physician to prescribe these emergency shots to the school itself, so the school nurse or some other administrator can have them on hand if needed. There is one amendment to the bill that clarifies the fact that this is a permissive bill, does not require any school to have these on hand, but simply allows them to do that. Mr. Speaker, that's pretty much what the bill does. It's a good thing for our school systems and kids there. If there are not any questions, I'd ask for your favorable consideration.
You don't appear to have any questions.
Thank you, Mr. Speaker.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Clerk will read the amendment, the Fleming Amendment, AM 33-1299.
Representative Fleming, 121st, offers the following amendment. Amend House Bill 337. The amendment has been printed and placed on your desk earlier today. It's upper right-hand corner, AM 33-1299. Amendment by Representative Fleming, 121st.
Is there any objection to the adoption of the Fleming Amendment? The chair hears none. The amendment is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 337 will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 337. The ayes are 169, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 125. House Bill 125.
House Bill 125 by Representative Hightower, 68. A bill to be entitled Act entitled 50 related to verification of lawful presence within the United States so as to provide for a certain affidavit for persons under 18 years of age to be executed after attaining the age of 18. Provide requirements for the submission of documents, provide that certain documents may be submitted by facsimile. The bill having been for the House Committee on Judiciary Non-Civil. The committee recommends the bill passed by committee substitute. Bill is being read today for third time.
Chair recognizes Representative Hightower to present the bill. Representative Hightower.
Thank you, Mr. Speaker, members of the Assembly. I bring before you a substitute to HB 25. During my campaign, I promised many of my constituents I would try to find ways to promote business and be a good steward of taxpayer dollars. HB 125 has given me a good opportunity to make good on that promise. HB 125 streamlines many of the processes for obtaining a professional license and public benefits while maintaining strict requirements of those trying to obtain a professional license or public benefits. How will HB 125 accomplish this? Under current law, anyone who attempts to obtain a professional license, such as an electrician, plumber, nurse, realtor, or appraiser, just to name a few, must provide certain secure and verifiable documents proving their lawful presence within the United States each and every time they apply or renew their professional license. The major delay that HB 125 aims to fix can be found in the renewal process. HB 125 would change current law to allow U.S. citizens renewing an application within the same state agency or political subdivision to not have to resubmit all these documents each and every time. They'd only have to do it upon the initial application. This is a very common sense approach to this problem. If you've proven you're a U.S. citizen once within an agency, you do not have to keep proving to the same agency you're a U.S. citizen each and every time you renew for a public benefit or professional license. However, if you're not a U.S. citizen, you would have to provide your full set of documents each time you apply or renew. HB 125 also takes the same common sense approach when it comes to issuing a business license from a county or municipal corporation. Right now, on the municipal level, if you're applying for a business license, you do have to provide certain documents each and every time you apply for that business license or renew that business license. HB 125 would aim to fix so that you only have to do that upon when you're applying for the business license. You would not have to resubmit all these documents upon the renewal of your business license. HB 125 also clarifies a couple other things that was done prior. Just a couple of things that needed clarification. One is it does a better streamline when it comes to making certain reports. What this does is right now there's current reporting requirements that have to be done in three different reports to two different agencies. What HB 125 will do is it gives a certain outline of what report is needed, and you only have to do one report a year to one agency. So it's definitely a streamlining government process. Mr. Speaker, I'll yield to any questions.
You have some questions. Do you yield?
I'll yield.
Chair recognizes the minority leader of the House to your left for a question.
Thank you, Mr. Speaker. Representative, will you yield?
Yes, ma'am.
Looking at page 6, line 178. This bill now adds to the list of public benefits homestead exemptions. Is it not true that this would now require that every person who receives the homestead exemption in the state of Georgia will be required to submit proof of citizenship in order to receive that benefit?
You would have to do that one time. After you've done it once, you would not have to keep doing that, because that would fall under the provision that we have here that says once you've supplied your proof of citizenship to the state agency, you do not have to resubmit that each and every time.
Thank you.
Yes, ma'am.
Chair recognizes you further yield.
Yes, I'll further yield.
Chair recognizes Representative Henson to your left for a question.
Thank you. Will the gentleman yield?
Yes, ma'am.
Thank you. I'm looking at the House Rules calendar for Monday. I'm looking at House Bill 125, and I'd really like to know what this has to do with executions, because it says certain affidavit for persons under 18 years of age should be executed after attaining the age of 18.
This bill has nothing to do with executions.
I understand that, because, I mean, you know, I have a bill that's dealing with whatever it's dealing with at this point, immigration and compliance and everything, and yet I'm reading what's being put out, talking about executions, and I'm very confused. Why is that?
I can reference you to the bill. If you go to lines 247 through 251, what that referencing was made, and what that is in reference to is execution to execute a signed and sworn affidavit verifying the applicant's lawful presence in the United States under federal immigration law, provided, however, that if the applicant is under the age of 18 years at the time of the application, he or she shall execute the affidavit required by this subparagraph within 30 days after his or her 18th birthday.
That's quite different than being executed, isn't it?
It is. We are not executing anyone over the age of 18 with this bill.
Thank you. Would you yield for a further question that doesn't deal with executions?
I will yield.
Okay, I really want to take you back to the question that the minority leader asked about homestead exemptions.
Yes, ma'am.
Does that mean that every citizen who is applying for homestead exemption, whether they've been doing it for 1 year or 30 years, that they're now going to have to go in to show that they're a legal citizen of the United States like we did with driver's licenses?
My understanding is that you will have to prove that one time, and that once you've proven that once, you will not have to prove it again.
Okay, follow up?
Yes, ma'am.
So I'm going to have to go in and prove them a U.S. citizen.
That's my understanding.
Next time I ask for a homestead, but there's a difference between driver's licenses, which are staggered over a 12-month period of time, and the homestead exemption, which is at one specific period of time. So have you dealt with our tax officers as to whether or not they're going to be able to take the load of people coming in to prove that they're U.S. citizens, and can it be done by mail? And how are we going to notify anyone, and what's the cost involved with this?
Most of what this says, there's also a couple other provisions in here that says that any verifiable document can be submitted by mail. It can be presented by someone on your behalf. It can also be submitted electronically. And there's a couple of different provisions in this bill that specifically go to that question to try to streamline this process. As far as anyone said, if they're going to be able to meet that burden, no one has come to me yet and said that they had any issues with this bill. This bill is actually currently, and you can see on your desk, it's been supported by NFIB. It's also supported by the Georgia Chamber. It's also been supported by GMA and ACCG. All of those individuals helped throughout the process of this bill and are in open support of this bill.
May I follow up?
Yes, ma'am.
I'm still going to ask what the cost will be involved and how the folks, every homeowner in the state of Georgia, is going to be notified that they have to now submit documentation, including our elderly and some of our folks who really have a difficulty with reading, and how they're going to understand this, and what penalty there'll be if they don't comply, and also when this goes into effect.
Well, I'm not sure how those that have a difficulty with reading, other than leaning on their neighbor. I mean, my grandfather, in all honesty, he can't read. But I know when he has problems with things, he calls me, and I read it to him. So those that have difficulty with reading, they may have to go and find someone they trust, they believe in, to give them that notification.
And again, is there fiscal note with this for what it's going to cost in providing the extra workload that's going to, because this is basically a mandate that we're passing down.
What we're doing here is actually streamlining things in state government. There's not a fiscal note attached, but what we're making it here is easier for people to get a professional license. We're making it easier for people once they've done the initial hurdle, instead of making them jump through that hurdle again and again and again. We're making it easier for them to get their professional license or get a public benefit, because once they've established their citizenship once, they don't have to do that again and again.
Excuse me, and I just want to make one correction. I have no problem with anything in this bill except the homestead exemption.
I understand.
And you're taking me into licenses, professional licenses, where I thoroughly agree with you.
It would go also to the homestead exemption. You would only have to prove that you're a U.S. citizen once, and then once you've done that, then you'd be okay.
Further, people who have professional licenses are looking at what's on the computer. They do look at what they have to provide. They do look at all of that. People who own a home, especially our elderly, are not looking at the new thing every year. You know, they checked it off 30 years ago or whatnot. They are used to getting a bill and paying a bill. They're not looking at all new laws coming down that suddenly they now have to prove that they're a U.S. citizen because they own a house in the state of Georgia.
Yes, ma'am.
Thank you.
You have a lot of questions.
I'll yield for one more, Mr. Speaker.
Chair recognizes Representative Oliver to your left for a question.
Does the gentleman yield?
Yes, ma'am.
I have a slightly different question about the homestead exemption. Is it your policy in suggesting we pass this bill that wealthy businessmen who are citizens of Germany but are permanently legally assigned to Georgia should not be entitled to a homestead exemption?
What I'm saying with this bill is that if you're a U.S. citizen, then you'll have to prove that once. Now, if those guys are privileged to a homestead exemption under some other mechanism within our law, then they'd have to explore that mechanism.
Does the gentleman further yield?
Yes, ma'am.
I believe you are taking away a homestead exemption of tens of thousands of businessmen from Europe and Japan and all over this world that own property. I know several in my neighborhood that are here with Emory University but are citizens of another country but certainly own their home here in DeKalb County. Is it your intent to change the law in relation to their entitlement of homestead exemption?
My intent is to make it so that if you're going to get a homestead exemption, you need to be a U.S. citizen and be able to prove that at least once. And once you've proven that, you don't have to prove it again.
Final question. So it is your intent to change the law, if I'm correct, that...
My position stays exactly the same.
Chair recognizes Representative Ramsey for a question.
Thank you, Representative Hightower, and thank you for the excellent work on this bill. Is it not true that individuals that are lawfully present in the United States, not just citizens, would still be able to qualify for a homestead exemption? And this bill in no way modifies who's eligible to receive a homestead exemption or not.
That's correct.
This simply adds homestead exemption to the huge list of public benefits that require one time to prove that you're lawfully present in the United States. And if an individual's already received a public benefit from that political subdivision, they in fact wouldn't have to go in and go through the process again, even if they're applying for a new homestead exemption.
Thank you for that clarification. That is correct.
Thank you.
I yield the will, Mr. Speaker.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 125 will vote yes. All those opposed will vote no, and the clerk will unlock the machine. What purpose does Representative Dukes rise?
Parliamentary inquiry, Mr.
State your inquiry.
Mr. Speaker, I have some concerns, and that is on line 187, I would have preferred to ask it to the author, but it lists retirement benefits as one of those things that you have to prove citizenship for. If a person comes and works and pays into a system, is it not true that those are benefits that that individual has earned?
Well, we're voting now, Representative Dukes, and I'm not going to try to interpret what the legislation says. I mean, you can read that if the author's over there, not far from you, if you wish to go have a discussion with him before we lock the machines. Have all members voted? Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 125. The ayes are 116, the nays are 49. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 124. House Bill 124.
House Bill 124 by Representative Harrell, the 106th. Bill to be entitled Act amending Code Section 3-3-7, relating to local authorization, regulation of sales of alcoholic beverages on Sunday to provide that an election in which the votes cast are for disapproval of Sunday package sales by retailers of malt beverages, wine, and sales spirits shall not nullify the prior election results for approval of Sunday package sales by retailers of malt beverages, wine. Bill has been for the House Committee on Regulated Industries. The committee recommends bill passed by substitute. Bill's being read today for its third time.
Chair recognizes Representative Harrell to present the bill. Representative Harrell.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring House Bill 124. In Section 1, it provides that in a local community that has previously approved the Sunday package sales of beer and wine and then chooses to have a subsequent election, for example, if they permit a liquor store, and that referendum would then be for beer, wine, and spirit. Should that subsequent election fail, it would not nullify the prior approval of beer and wine by package on Sunday. Section 2 adds a definition of what that retail package store is that says a business primarily engaged in the sale of beer, wine, and spirits, meeting 75% or more of their gross sales. That is the bill. I would be glad to answer any questions.
You have no questions.
Thank you, Mr. Speaker. I appreciate your favorable consideration.
The gentleman has yielded the well. What purpose does Representative Chokas rise?
Mr. Speaker, pursuant to House Rule 133, I would like to be excused from this vote.
Gentleman has that right. The journal will so reflect. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 124 will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 124. The ayes are 161, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 131. House Bill 131.
House Bill 131 by Representative Clark, the 101st. A bill to be entitled Act amending Title 20 relating to educational programs so as to define a term. Rather, that dual credit courses shall be treated in the same manner as advanced placement and international baccalaureate courses for purposes of determining eligibility for the Hope Scholarship. Bill has been for the House Committee on Higher Education. Committee recommends the bill passed by committee substitute. Bill's being read today for its third time.
Chair recognizes Representative Clark to present the bill. Representative Valerie Clark.
Thank you, Mr. Speaker, and ladies and gentlemen. I bring for your consideration House Bill 131, and this is a consumer-friendly education bill. This bill provides that dual enrollment classes be given the same advantage as advanced placement and IB International Baccalaureate classes when determining eligibility for the Hope Scholarship. An advanced placement class, or IB, these are college-level classes that a student can take in high school. And these are much more rigorous, so school systems often reward students for taking them with added points to their final teacher grade. Nothing to do with the advanced placement exam. This is on the teacher grade. So, Mr. Speaker, when you receive your 97 in your final grade in advanced placement biology, your grade on your transcript would be as much as 107. This gives you a tremendous advantage when you're competing for top honors, as I'm sure you were, valedictorian or salutatorian of your class. Please note that these extra points are added again to the teacher grade and not anything to do with the AP exam. Because of these inconsistencies, some counties give 5 points, some counties give 10 points. All of these points are erased when they go to the Georgia Student Finance for Hope Scholarship determination, and they give a 0.5. This bill asks that the same advantage be given to dual enrollment, and dual enrollment is defined as a college class taken for both college and high school credit in an accredited college or university. At line 119 specifies that dual enrollment courses must be in core subjects to be considered for any advantage, and line 162 reads that the Georgia Student Finance Commission shall be authorized to promulgate rules and regulations necessary to carry out the intent of this subsection. So that means they may determine the courses that count toward this 0.5 weighted advantage given to any grade. In summary, ladies and gentlemen, a student taking dual enrollment classes taught by a college instructor does not at this time receive an additional 0.5 to calculate the Hope Scholarship average, even though it's a bona fide college class taught in an approved post-secondary setting. Second, these students do not receive the additional points that Speaker Ralston received. These points remain on their transcript when they go to college, and a student who receives, again, an 85 in a college class maintains that 85, but that student in an advanced placement class would receive a 95 that goes to the college on their transcript. The AP student receives this final advantage plus the 0.5 toward Hope Scholarship, without the addition of the AP exam. This exam score is returned midsummer and has nothing to do with this grade. The dual enrollment score is based on coursework plus a final exam grade taught by a college professor and does not at this time receive any advantage. In this bill, students are given a choice of learning settings. In summary, this bill has been approved by the governor's advisors and the Georgia Student Finance Commission. Also, it's further supported because students have not taken advantage of dual enrollment in the numbers anticipated by the governor's office. And the governor's office would like to promote this seamless transition into college. Ladies and gentlemen, I ask for your favorable consideration of House Bill 131, and I relinquish the well.
You have no questions, and the lady has yielded the well after some revisionist history there that she was engaging in. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 131 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 131. The ayes are 169, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 192. House Bill 192.
House Bill 192 by Representative Kidd, 145th. The bill will be entitled Act amending Code Section 4335.3 relating to definitions regarding podiatry practice, provide that podiatric medicine includes diagnosis, treatment of cosmetic conditions regarding the human foot and leg. Bill has been for the House Committee on Health and Human Services. Committee recommends bill passed by substitute. Bill is being read today for the third time.
Chair recognizes Representative Kidd to present the bill. Representative Kidd.
Thank you, Mr. Speaker.
Just a minute, Representative. And we've still got some bills to get through here. So the chair is going to ask that you remain seated, keep conversations non-existent, pay attention to the members in the well. Representative Kidd, proceed.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring to you House Bill 192. It deals with the Podiatry Practice Act. It does not, and I repeat, it does not add any additional language or service to their scope of practice. The only thing it does is add the word cosmetic in their Practice Act so they can use the cosmetic CPT codes, because in some cases removal of a birthmark or a wart or getting some young lady's foot altered so they can get in those high pointed shoes you see wandering around here. It's not a medical necessity, but it's a cosmetic. And so with that, Mr. Speaker, I will yield any questions or yield the will.
You have a question if you care to yield. A couple of questions.
Yes, sir.
Chair recognizes Chairman Rogers to your right for a question.
Thank you, Mr. Speaker. Cuz, will you yield?
Yes, sir, Cuz.
You said it doesn't expand the Practice Act, but I noticed legs are included. I thought podiatrists only worked on ankles and feet.
No, sir, they work on anything distal to the knee. So this doesn't add any scope of service to it. They can set broken legs, they can set broken feet, they can set broken ankles. They are equal to an orthopedist below the knee by law.
Okay, thank you.
You have another question if you care to yield.
Yeah, I'll take one more, Mr. Speaker.
Chair recognizes Representative Spencer to your right for a question.
Does the gentleman yield?
Yes, sir.
On the line 17, it says spider veins. Is the podiatrist scope of practice including, I'm assuming we haven't defined spider veins in the code, is that varicose veins, vascular surgery?
It can be, yes, sir. Here again, they're licensed to do that right now. So this doesn't add any new service to what they're currently licensed to do. It just adds the word cosmetic so they can use the cosmetic CPT code.
Okay, thank you.
Thank you, sir. With that, Mr. Speaker, I'll yield the will and urge your favorable consideration.
Gentleman has yielded the will. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bills? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 192 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 192. The ayes are 161, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 361. House Bill 361.
House Bill 361 by Representative Lindsay of the 54th, a bill to be entitled Act Title 34 relating to membership in labor organizations, provide for definitions, statement of rights under federal law, provide for a certain contract and agreement employment rights, to provide for policy concerning passage of laws, ordinance, contracts that waive or restrict federal labor laws, provide for changes in agreements, contracts permitting labor organizations to deduct fees for employees' earnings, to amend Code Section 16721 relating to criminal trespass, provide that both criminal trespass and criminal conspiracy, provide for punishment and fines, provide for related matters. Bill having been before the House Committee on Industry and Labor, the committee recommends the bill do pass by substitute. Bill's being read for the third time.
The Rules Committee has adopted pursuant to Rule 33.3 a rule that debate would be limited on this bill to not more than 1 hour, with the time to be allocated at the discretion of the chair. The chair will allocate 30 minutes to each side. That will not include the chairman's report, nor will it include the minority report, if any. Chair recognizes the Majority Caucus Whip, Representative Lindsay, to present the bill. Representative Lindsay.
Thank you, Mr. Speaker. Georgia is a right-to-work state. Now, I think it bears repeating a second time. Georgia is a right-to-work state. That needs to be said twice because throughout the hearings on this particular bill, it seemed to be lost on a lot of people who testified and folks who voted against this bill as to whether or not we were actually debating whether or not Georgia should be a right-to-work state. This has been a long-term established policy of this state, and what House Bill 361 and its companion, which I will speak to in a few minutes, House Bill 362, simply seek to reinforce. As a result of Georgia's right-to-work status, Georgia is recognized in this nation and around the world as a business-friendly state, and we have profited greatly from that recognition over the last 60 to 70 years. Businesses choose to relocate from less friendly states to Georgia and from other countries to Georgia, in large part due to Georgia's status as this right-to-work state. As a result, Georgia businesses have prospered, and the unions operating in this state understand that they must stay closely attuned to the needs of their members in order to continue to exist. What HB 361 and HB 362 simply do is reaffirm and strengthen this right-to-work status that has worked so well for the state of Georgia. Let me speak specifically to House Bill 361 now, and I'll return in a few moments to speak to House Bill 362. What House Bill 361 merely does is protect workers by allowing them to opt out at any time from a union and halt immediately payroll deductions to such unions that they don't believe are answerable to their needs. The bill is supported by the National Federation of Independent Businesses, the Chamber of Commerce, and workers who oppose untoward coercion throughout this state. That's simply what HB 361 does, and Mr. Speaker, I'll be happy to answer any questions, if there are any.
You have questions.
Happy to take a few.
Chair recognizes Representative Flood to your left for a question.
Thank you, Mr. Speaker. Would the gentleman yield?
Yes.
Can you explain to me, please, lines 71 through 78? I've tried to read it more than once, and can't seem to understand exactly what you're trying to convey there.
It basically, all it's really doing here is reaffirming federal law regarding our rights as a right-to-work state.
Will the gentleman further yield?
Yes, sir.
What's the reason for reaffirming federal law?
I think it's important for us to make it very clear that we, as a right-to-work state, are operating well within federal law. One of the arguments that are being made against this bill is that somehow we're being preempted by federal law, and we can't do this. And all this particular provision does is show that we are acting well within our rights as a right-to-work state.
Will you further yield?
Yes, sir.
Are there questions about whether or not Georgia is a right-to-work state?
No, there were questions raised by opponents of this bill as to whether or not we had the power to do that, which we have, and all this particular provision does is establish that particular right, to clearly lay out the public policy of the state of Georgia.
Is there some assault on the public policy of the state that has generated the need for another piece of legislation?
I think that what we're trying to do here is reaffirm and strengthen our position as a right-to-work state, as shown by the following two sections to the bill, which simply makes it very clear that a worker can at any time opt out of a union and cease having their dues deducted from their payroll.
Thank you.
Chair recognizes Representative Bruce to your right for a question.
Thank you.
Will the gentleman yield?
Absolutely.
Just as a matter of clarification, we keep saying the term, and we make up names for these bills, and we keep calling it right to work. But is it not really more the right to fire that we're talking about?
No, sir, it's not. And once again, I thank you very much for that question, because your question clearly shows that what the opponents of this bill are arguing is not against what's contained in this bill, but the fact that Georgia is a right-to-work state. And that's not just a term that's been made up. That's a term, that's a recognized principle, that's something recognized in law as to what type of state we have chosen to be. I'll take one more, Mr. Speaker.
Chair recognizes Chairman Hamilton to your right for a question.
Yes, sir.
Does the gentleman yield?
Absolutely.
Is it not true that this bill went through a full subcommittee meeting with full testimony, another full committee meeting, and then after sending it to rules, we sent it back for another full committee hearing?
That's absolutely the case.
Is it not also true that after the second meeting that a minority report was filed, but after we sent it back to the full third committee meeting, of which we amended, putting language in there that the unions had asked for, that not only did it pass, but it passed unanimously from that committee, of which there was 3 of the opposing party on there that voted for this bill?
That's correct, and I think that's also a good point, in that this bill was something that's been vetted very heavily by your committee. We took very seriously suggestions from both sides on this bill. As a matter of fact, we agreed to adopt some of the concerns that were raised in the original version.
And one final committee yield?
Yes, sir.
Is it not also true that even a member of the committee of the opposing party acknowledged that they weren't against the bill, but they were against the simple fact that Georgia is a right-to-work state?
That's exactly what was said, and was also repeated by numerous witnesses, that their problem with this wasn't the bill itself, but the fact that we are a right-to-work status. So I believe that goes also to Representative Flood's question as to whether or not our status as a right-to-work state is under assault. I believe it is, and it's time for us to stand up and reassert our position as a right-to-work state. Mr. Speaker, this bill is fairly simple and straightforward. If you are in favor of Georgia remaining a right-to-work state, please vote for it. If you oppose Georgia being a right-to-work state, I do understand you vote against it. I ask for your favorable consideration. Thank you.
Gentleman has yielded the well. Chair recognizes Representative Kirby to speak to the bill. Representative Kirby.
Thank you, Mr. Speaker.
I rise today in support of House Bill 361. As we look at this bill in pretty simple terms, we're reinforcing that both employees and employers can freely express their opinion and under a secret ballot election have no fear of reprisal, no fear of pressure being put on them to freely exercise that right. As we move forward in this bill, you also see that it does protect some personal and sensitive and private information from getting out in the public realm, which is very important. And yes, this is covered under federal law. Matter of fact, if you looked at the Taft-Hartley Act in Section 1, just the introductory part, it says it's to promote the full flow of commerce, to prescribe the legitimate rights of both employees and employers and their relations affecting commerce, to provide orderly and peaceful procedures preventing the interference by either with legitimate rights of the legitimate rights of the others. And that's exactly what this bill does in Georgia, is codify that part of Taft-Hartley into our law. Mr. Speaker, I yield the well.
You have no questions? Okay, we'll reset the clock, and the chair recognizes Representative Flood to speak to the bill. Representative Flood.
Thank you, Mr. Speaker. This afternoon, ladies and gentlemen, I rise in opposition to what I would think my friend Representative Bruce would call the Workers' Deception Act. This is yet one more attack on unions in Georgia. And I agree with my friend from Davidson that Georgia is clearly a right-to-work state. I don't know that there's any disagreement. I don't think that there is likely to be any change in his lifetime or mine to that public policy position. Yet I've been unable to determine why we need this bill to restate something that we already know. Yes, we are a right-to-work state. We can say that again and again and again. We would still be a right-to-work state. I'm not sure that anything changes with that. It seems to me like this is really more of an attack on unions at a time when just over 4% of the workers in Georgia belong to unions. So it's like University of Georgia picking on Davidson. That's not a fair fight. Let me share a little bit about what unions have done for workers in this country. It's because of unions that we have a 5-day work week. It's because of unions that many people have a living wage. And they've frankly been able to help create a middle class throughout the state and certainly here in Georgia. Unions raise the average salary of workers at about 15%. They've promoted the implementation of employee benefits plans. Family and medical leave exists because of unions. And to give you another perspective, last month we recognized A. Philip Randolph. And if you remember what we discussed, A. Philip Randolph organized the railroad workers into what is known, or what was then known as the Brotherhood of Sleeping Car Porters. This was done in the 1920s. Now, private sector workers had begun to organize back during the Depression, but public sector workers weren't really allowed to organize until the 1950s and 60s. And along with the advent of the civil rights movement, the economic growth of public workers played a major role in creating what became the black middle class. Black workers were more than likely to work in public sector jobs because even with education and technical skills, they faced still a fair amount of discrimination in the private sector. And so because of access to jobs in the public sector, there was an opportunity to create what has become a growing and thriving black middle class. And so I still, again, am trying to determine, after reading the bill, time and time again, what exactly Representative Lindsay is trying to achieve, because the bill inserts language into the Georgia Code that simply restates employer rights under federal law. such as the handling of union organizing efforts. The bill also reiterates that the state and local government can't impose labor rights that are not granted under federal law. It enumerates the employer's rights, but I'm not sure that it outlines, in fact, I'm sure it doesn't outline the workers' rights in the same fashion. Line 71 starts with no governmental entity may pass any law relating to collective bargaining, essentially, which takes away the control of local government from cities and counties. Local governments ought to be allowed to do what they wish. So I ask the question to you, what is the point of the legislation? What is the purpose? What is the problem this bill is seeking to solve? There's no assault on public policy position of the state. And at a time when our citizens are calling for less government, I fail to see the value of creating yet another piece of legislation that does nothing but state the obvious. Representative Lindsay posed the question, which was, vote yes if you believe or support Georgia being a right-to-work state, and vote no if you believe that Georgia should not be a right-to-work state. Now, clearly, that is not the question at hand today. However you vote, yes or no, Georgia will continue to be a right-to-work state. What you're voting on is, do you want more government involvement or less? What you vote for or vote on in this bill is whether or not you want additional legislation that seeks to solve no problem that exists, but still provides more government intrusion. So the real vote is, if you're for less government, then you vote no on this bill. Thank you, Mr. Speaker. I yield the well.
Gentleman has yielded the well. Chair recognizes Representative Frazier to speak to the bill. Representative Frazier.
Thank you, Mr. Speaker. To my colleagues in the House, I rise to oppose House Bill 361. And respectfully to Representative Lindsay, we should be asking the question, are we proud to be a right-to-work state? Are we proud to say that Georgia is a right-to-work state? As the co-chair of the Georgia Working Family Caucus, I work with all the unions in the state. I'm not speaking on behalf of the Georgia Working Family Caucus, I'm speaking on behalf of Representative Frazier. And I'm concerned about the fair treatment of the core of this state, which is the working families. Are we proud to be a right-to-work state? I'd like to give you a few stats about right-to-work states. By many measures, the quality of life is worse in states with so-called right-to-work laws. Wages are lower, poverty and the lack of insurance are higher, education is weaker by the evidence of our local school systems. Even infant mortality and the likelihood of being killed on the job are higher. States with right-to-work laws, the average worker in these states make $1,540 a year less than other states. Median household income in states with these laws is $6,400 less in other states. Give you an average salary of about $46,000 versus $52,000. In states with right-to-work laws, 26.7% of jobs are low-wage occupations, compared to 19% of jobs in other states. Are we proud to be a right-to-work state when the poverty rates are higher in states with right-to-work laws? Like 21.5% for our children, compared with poverty rates of 13.1% overall, and 18.1% for children in states without these laws. The infant mortality rate is 15% higher in states with these laws. States with right-to-work laws spend $3,300 less per pupil per expenditure on their students. And like we all say, you get what you pay for. If you do not invest in our education system, we do not produce workers for the state of Georgia. So the rate of a workplace death is 36% higher in other states. And this data is coming from the Bureau of Labor Statistics. So the bottom line is, House Bill 361 interferes with the principles of free market and personal responsibility by giving employees unlimited power over employees. These are our working families that we depend on in the state to generate revenue, the working families. So is it fair for them to be subjected to a bill that I see warrants has no merits? Representative Lindsay stated that the purpose of this bill is to reaffirm what we are already doing by federal law. Where if it's not broke, we don't need to fix it. So I say to you that I stand here today in opposition, and I hope that you will too, because I'm not proud to say that Georgia is a right-to-work state, because we are a poor state. And it is up to us to make sure that we have fair laws that will protect our working families. So I urge you to vote no on House Bill 361 and think about the Georgians that are working to preserve this state. Thank you, Mr. Speaker. I yield the will.
Okay, that is all of the members that had signed up to speak on the bill. Is there any objection to the previous question being ordered on House Bill 361? The chair hears none. The previous question is ordered. There is a minority report. There is a minority report. Under the rules of the House, the presenter on the minority report will have 20 minutes, after which the chair of the committee will have the closing word. The chair recognizes to give the minority report Representative Marin. Representative Marin.
Thank you, Mr. Speaker. Good afternoon. Buenas tardes a todos. We're still opposed to these bills because it's a still attempt to single out and create hardship for union members that are being held to a different standard than members of any other organization. Like Representative Fraser was mentioning, it interferes with the principle of the free market and personal responsibility by giving employers unfettered powers over employees. This is not fair, and it's not good for business. We believe that government should stay out of the way of the free market. Then you should if you know that and you believe in that, you should let business make the choices and best allows them to succeed or fail. We have several companies like AT&T, UPS, and Kroger that work closely with labor. And we just had a couple of weeks ago in the news and TV about Lockheed Martin, that they were going through some struggles through the budget process and at the federal level. They came out publicly in TV saying that labor and management were working better than ever. So Georgia is the right word to state, and that respects personal responsibility. It is a matter of personal responsibility for employees to decide if union membership is best for them. It also takes businesses being responsible to treat employees with dignity and respect. If the free market is in the government's job, it is the government's job to enforce the laws, not to pick winners and losers. The free market will determine whether industry and labor succeeds. One doesn't succeed without the other. Labor unions provide due process protection. This is very important. Militate against favoritism and nepotism, and allow for employee whistleblowing against workplace concerns like sexual harassment and retaliation. Georgia should not make laws that burden multi-state companies and drive their workers to more friendly states, to make Georgia home and to work better. With that, Mr. Speaker, I've strongly come with a minority report opposing HB 361, and I hope you do the same. Thank you.
Chair recognizes for the chairman's report the chairman of the Industry and Labor Committee, Chairman Hamilton.
Sorry about that. Thank you, Mr. Speaker. I won't be long. I just want to say a couple of things. This bill was fully vetted. We had 3 full meetings. The last meeting, with opposition there, it passed unanimous. I love to hear things about free market and personal responsibility. That's what this bill does. It says that these people are going to have the right and the ability, if they don't want to join the union, they can step out of the union. If they don't want to pay their dues after they've left, they don't have to. I don't know how much more personal responsibility you get. Mr. Speaker, we've debated this long enough, and I'm going to would like to yield my final time to the author of the bill. Thank you very much.
Gentleman has that right. He yields his final 19 minutes to the Majority Caucus Whip, Representative Lindsey.
Thank you, Mr. Speaker. I won't take anywhere close to that amount of time. Let me just sort of hit on a couple of quick points. Representative Flood questioned whether or not Davidson could take on Georgia. I think any day, any night, particularly if it's an academic bowl, we'll do just fine. Number 2, and more seriously, whether or not this is an anti-union bill, absolutely not. It is a pro-worker bill in terms of making sure that unions that do exist in this state and operate in this state operate in the best interest of their workers rather than the best interest of themselves. Because while we can point to gains in our society as a result of some of union activities in our history, we can also point very clearly to problems that have occurred as a result of unions running amok and forgetting that in order for them to thrive, the businesses must also thrive. And let me just name to you a few that have impacted the state of, 2 that have impacted the state of Georgia. 1, Eastern Airlines. 2, Hostess. And in addition to those 2 employers that were hurt here in the state of Georgia as a result of unions that have run amok, let me mention also a city that has declined and fallen from its great status so many years ago, a little city called Detroit. Now, one of the speakers here a few minutes ago questioned whether or not businesses will be leaving Georgia as a result of legislation like this versus coming to Georgia. And let me sort of point to you 2 states that have historically been hostile to right to work, but have changed their tune as a result of their final recognition that this kind of law is both pro-business and pro-worker. 2 states, Michigan and Indiana. Mr. Speaker, once again, I simply say this. This is a bill that reaffirms our status as a right-to-work state. It is a bill that gives workers clear choice as to whether or not to belong to a union and mandates, by doing so, that unions remain relevant to their needs rather than to the needs of union bosses. Therefore, I simply ask you, if you stand with me and recognize Georgia as a right-to-work state, vote yes. Thank you.
Gentleman has yielded the will. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee which was favorable to the passage of the bill. The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 361. The ayes are 110, the nays are 57. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 362. House Bill 362.
House Bill 362, Representative Lindsay of the 54. A bill to amend Title 50 relating to bonds for public works contracts, competitive award requirements, and general authority duties and procedure relative to state purchasing respectively, so as to provide for certain contracting bidding requirements for governmental entities and the Department of Administrative Services. Bill having been for the House Committee on Industry and Labor, the committee recommends that this bill do pass. Bill is being read today for its third time.
Chair recognizes the Majority Caucus Whip, Representative Lindsay, to present the bill.
Thank you, Mr. Speaker. Just very briefly, since we've already had a full debate on 361 and the general public policy regarding right to work, let me sort of get right to the point on what House Bill 362 does. House Bill 362 prevents the state or any kind of local government or any governmental entity in this state from going through the back door what we have prohibited through the front door in regards to our right to work status. Specifically, what it does is it bars any local government or the state of Georgia or any other governmental entity from mandating that a bidder on a public contract utilize union labor. That's essentially all that the bill does. It simply protects our bidders in terms of allowing them to choose for themselves whether or not to include union labor as part of their bidding process. It doesn't, in no way bans the use of union labor. It simply bans any type of governmental entity coercing a private company into being forced to use union labor. That's all the bill does, Mr. Speaker. I'll be happy to take any questions, and if there are none, I will yield the well.
There are no questions.
Thank you, Mr. Speaker. I ask for your favorable consideration to House Bill 362, and let's once again reaffirm Georgia's status as a right-to-work state.
Gentleman has yielded the well. The chair recognizes Representative Kirby to speak on the bill.
Thank you, Madam Speaker. I could just simply repeat a lot of what we heard before from our colleagues that were opposed to 361. This is about leveling the playing field. This is about making sure that we are not here picking winners and losers, but simply allowing anybody and everybody to fairly and freely bid on any jobs. We should not be down here supporting one entity or business entity over another. We should allow the free market to take its place and do what it does best. And that is to allow both union, non-union, and anybody else who's qualified to do the work to bid on any contracts in state or local government. And that's what House Bill 362 is going to do. It reinforces that free market, allowing everybody to participate fairly and equitably on a level playing field. I yield the well, Madam Speaker.
There are questions if you wish to answer. Chair recognizes Representative Drenner for a question.
Thank you. Does the gentleman yield?
I will yield.
Representative, do you believe in local control?
Do I believe in local control? Absolutely, I believe in local control.
If you believe in local control, as you just now stated, then why would you support a bill that would remove local control from local companies that wished, or local governments that wish to set rules contrary to this particular bill?
Because the rules you're talking about giving somebody an unfair advantage. Local control means they have the right to accept those bids, and if they want to accept a bid for any reason, they have that right to do that. They have the control of what bids they're accepting. This is a problem we've got, is when you start restricting who can bid, now you're making the playing field uneven and unfair for some businesses to compete in, and that's what we've got to prevent.
Is it not true that local governments are elected by local people?
Yes, they are.
And so therefore there's a process in place, therefore, to eliminate local people from those positions?
To eliminate local people from those
Yes, those elected.
No, is pretty much in our Constitution, you have to live in your district that you run for other than Congress.
In other words, Representative, if somebody did not like a local provision, could they not vote someone out of office at the local level?
If somebody, the voters have the exercise their right to vote who they see fit to vote for.
Absolutely. So in essence, what you're saying is that you are usurping the authority of local individuals who elect local officials that may want this type of law in their locality. You are actually circumventing or usurping their right. Is that not true?
No, that is not true. Because they could choose to recognize whatever bid they want. We are just making sure that they're getting fair and even bids from everybody.
There are no more questions.
I yield the well.
The gentleman has yielded the well. The chair recognizes Representative Williams to speak on the bill.
Thank you, Mr. Speaker. I just wanted my friend from North Fulton to tell me once again, what are we? A right-to-work state. I've got it. I've got it. The only thing that I have not gotten is what has given business a problem doing business in Georgia. We're the fourth best place in America to do business. Where is this boogeyman that you can't find? There is no problem doing business in Georgia. And I'm still trying to figure out what brings about the need for this bill. At one point before the meltdown, we had so many Fortune 500 companies moving in until they could have moved Wall Street to the perimeter. Nobody has stayed away from Georgia because it's tough to do business in Georgia. The only thing that it has done, it has assured that people who need training, people, when you're looking for the best craftsmen available, the programs that the unions have in place have assured that the best labor available is here. The problem we have now is that the only people who call in the shots are the folk that are building outside, drawing the building, financing it. That's great. But they can't hang a light fixture. They can't hang drywall. They can't do the floors. Everybody has a role to play. Georgia does not have a problem doing business. I don't know who we're trying to send a message to. Because We're doing business. Kia didn't stay away from here because we had a labor problem. We're building plants, and as things increase and come back, we'll continue to build them. This is not a problem. If there's anybody that's got better labor than organized labor, they've certainly done a great job of hiding out. These are well-trained craftsmen. Georgia does not have a problem with doing business. I've heard the governor say so many times that he wants this to be the best place to do business in America. I have no problem with that statement. That's great. But it also needs to be additionally the best place to live, the best place to raise children, and the best place to make a living. What's wrong with everybody sharing a piece of this pie? Many of us in here that now oppose these things are middle class because your mom and daddy got a great job with labor benefits. And they came looking for those jobs. It made a middle class. And now all of a sudden workers should be relegated to minimum wages, and everybody is dressing this duck up in all kind of fancy clothes and made like it doesn't like water, waggle, and quack. But it's a duck. It ain't nothing but a duck. Now, the last time it got this bad, it was during the early days of the movement when folk got beat down in Detroit going to work and in the coal mines of West Virginia. My goodness, it's a beat down time for labor. We have built and would still have some of the great craftsmen in the world here. We can do anything and we can build anything, but we have created an atmosphere that is so anti-labor until everybody that's getting to build it are the folk that are working for slave wages in the Pacific Rim and Haiti and other places. What's wrong with a fair pay for a fair day's work? Nothing in the world. Heard all this talk about labor was killing this country. Labor's not killing this country. This country is not a country of the big landowner and the serfs. It's a land where everybody can make it if you've got the ingenuity and the willingness to work hard and do it. I agree, for the last 60, 70 years, this is a right-to-work state. But it should be a right-to-work state that also is a place where you have the right to make a great wage and build a great livelihood and be a solid part of the middle class. We're raising up a worker group of taco makers and hamburger flippers, forgetting about the great craftsmen that made this country great. Won't change anything. It looks like a party line vote. But don't worry about it. One thing about the great pendulum of time, it swings to the right and it also swings to the left. It's going to swing back when folk have heard enough and realize that they're not part of this great new revolution that's coming where everybody will get a chance at some good work. When folk are left out of it, there'll be another great uprise. And as new voters come on board, they'll look at who took care of the least among us. With that, Mr. Speaker, since I'm sure there are no questions for me,
There are no questions.
Thank you very kindly. I'll leave the well.
Gentleman has yielded the well. The chair recognizes Representative Holcomb to speak on the bill.
Thank you, Madam Speaker. I oppose House Bill 362 because it's unclear as to why this is needed. It creates a barrier to economic activity. And one of the points that Representative Williams brought up, I want to accentuate that a little bit more. We've all heard about how Georgia has underperformed in terms of employment for about the last 5 years. Our unemployment average has ticked about a point higher than the federal average, but there are jobs available for skilled workers. Many of the workers that we're talking about that have skills are found in unions. Unions provide training, they provide apprenticeship, and they create skilled workers, which are what we need in this state. And so with that, it's unclear to me why we would want to change our current existing law for contracts, which appears to be fair. It's been fair up until this year, so why does that somehow change right away? Within the language of the bill, if you take a look at it, it only allows these changes to the extent permitted by law, and then it also says that arrangements can be voluntary, and moreover, it provides an exemption to these requirements, and the exemption is an important exemption. It says that these rules can be not followed to avert an imminent threat to public health or safety, which seems pretty significant. If we're okay with averting or have an exemption under those circumstances, why not just have the playing field be as it is right now? Now, I want to be clear that I support measures that promote competition and put Georgians to work. In my opinion, this bill limits competition and may keep Georgians from working on local projects. I think that that's wrong. I'd rather have government agencies and local governments have the full range of options available to them, so that way they can make the best proposals that are right for their communities. For those of you who have read Adam Smith, let the invisible hand work. This bill, it legislates the marketplace, and that's not the direction that Georgia needs to go. And I'll leave you with three questions. Will this bill lead to more jobs in Georgia? The answer is no. Will this bill lead to more jobs in Georgia for Georgians? The answer is no. And will this bill ensure that taxpayer money is best spent? The answer is no. And so I encourage you to vote no for House Bill 362. Thank you.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. There is a minority report. For what purpose does Representative Quick rise?
Madam Speaker Pro Tem, I request to be excused from this vote in accordance with Rule 133.
You are excused. To present the minority report, the chair recognizes the minority leader, Representative Abrams.
Thank you, Madam Speaker. I will be fairly brief, but I did want to speak to a number of issues that were raised today regarding the distinction between HB 361 and HB 362. Representative Kirby raised the issue of winners and losers. That is a common usage of a phrase that comes from economic game theory. And game theory has this notion that some things are zero-sum, that if there is a winner, there has to be a loser. But there's also a theory in game theory that says that there is non-zero sum, that you can both win, you just won't be very happy. HB 362 interferes with a fairly consistent non-zero sum game theory that Georgia has operated under for years. There are some cities and counties that don't get everything they want. There are some unions that don't get everything they want. And there are some private contractors that don't get everything they want. But they have worked together in Cobb County, in the city of Atlanta, in South Georgia and in North Georgia to come together because they recognize that winners and losers happen every day. The goal is to maximize the winners. HB 362 strips away from local governments that very opportunity. It says to those companies, to those cities and those counties, to those labor unions and those private corporations, we're not going to let you play together anymore. We are going to decide that the winners and losers in this case will be determined on an arbitrary day by the state legislature, and you will have to live with the consequences. Now, the problem with talking about game theory and winners and losers is that most people really don't care. You slept through that part of economics on purpose, and you are really not happy with me bringing it up now. But the best part of economic theory is when you can make it relate to real life. So I will pose to you a hypothetical. Imagine, if you will, there is a city, a fairly large city, a city that, I don't know, at one point was the terminus of a railroad. And in that city, there grew to be a mighty, mighty economic force. and that city became the seat of government for the state of Georgia. Now also imagine, if you will, that a private company decided to bring some folks here to play football, and they played football so well they decided they needed a bigger stadium, a stadium that could open up and see the sky, maybe have a retractable roof. Let's further hypothesize that this stadium wanted to be in this city that was, had a really nice airport too. This bill would say that if that stadium were to be built using funds not provided by the state of Georgia, but by this city, that city would have very limited control over who got hired by those dollars. The problem is, Georgia and Atlanta have run through this hypothetical before. This is not the first time we've thought about building a stadium. This is not the first time we have made promises to local residents who live in the shadow of economic development only to see their livelihood decrease and decline. And year over year, we promise to those folks, we're going to help you this time. We're going to get you those jobs. The $200 million, the $1 billion that we will be pumping into this economy will finally make its way to your wallets. Under the provisions of this law, if the city of Atlanta decided that it wanted to make as a condition of pouring in $200, $300, $400 million, the requirement that folks in those communities be hired to do those jobs, it could not do so. And here's why. The reason stadium deals have been so failed in terms of hiring is that most often folks who live in those communities don't have those skills. So while the intention is good, the reality is impossible. You can't hire someone to do a job they can't do unless you train them. And there are one set of organizations in the state of Georgia that will provide free apprenticeships. They do so because they know that if they train these folks, they can eventually do the jobs, and those are labor unions. Labor unions in the state of Georgia have often been the source of training for trades all across the state, especially for construction. And yet, under the terms and conditions of HB 362, you would be prohibiting the city of Atlanta from, as a condition of spending $300 million, they would not be able to require that some portion of that contract be used to hire folks who were trained by labor unions to do the work. We are spending our dollars and spending our time trying to create winners and losers where we know where the losers live. They live in the shadows of our economic development. They live in the shadows of our decision making. We pick winners and losers in this building all the time. They're called tax credits. We pick winners and losers through the budget. This is the one day that we have decided that we should not have that right or responsibility. But I would argue that in game theory, as in moral theory, we have a larger obligation than simply catering to the folks who want more. We have to cater to those who need more. And so I would ask this body to vote against HB 362 and give Atlanta, give Georgians an opportunity to really have the right to work. Madam Speaker, I yield the well if there are no questions.
There are no questions.
Thank you.
The lady has yielded the well. Chair recognizes Chairman Hamilton to present the majority report.
Thank you, Madam Chair. You know, a lot's been said today, and I agree with virtually everything that the minority leader just said, but I have to take exception with part of it. I happen to own a staffing company. Guess what we do before we send them out on assignments? We train people. We put people on jobs that if they don't have the skills, we actually provide training, free training, so that we in turn can put those people out. There's many organizations around the state for either a fee or not a fee as part of their service. That's what they do. They provide training. What I do agree that was said is we're just simply not giving unions an unfair advantage. Why, when we spend public dollars, are we supposed to allocate or dedicate or mandate a certain percentage of those state dollars, those taxpayer dollars, to go to a particular group? I think it's just not necessary. There's nothing in this bill that would prohibit unions from participating in the building of this fictitious stadium here in Atlanta. Nothing at all. They simply are not going to get an unfair advantage simply because they are union members. And Madam Chair, I turn the rest of my time over to the Majority Whip. Thank you.
Chair recognizes Representative Lindsay to speak on the bill.
Thank you, Madam Speaker. I do agree with one of the opponents of this bill. Very little is going to be said here in the bill that's going to change anyone's mind, but I do think that we need to point out a couple of things. One is that I do believe that the opponents of this bill seem to be engaged in a case of mass schizophrenia, because I'm being told on one side, well, by virtue of this bill, you are picking winners and losers, and that's bad. And then I'm being told a few moments ago by my friend the minority leader, well, we should be picking winners and losers because that's good. Well, folks, this isn't about picking winners or losers. This is simply about leveling the playing field, not giving any entity that chooses to bid on a contract a leg up over another entity. The bids will be taken based on who can provide the work for the cheapest cost with the best quality. That's what should be the sole criteria for anyone who bids on a public contract in this state, whether it be from a local government or a state entity. That's the bottom line of what we are doing here. We are taking the best of what is a right-to-work philosophy and saying that everyone is going to be able to compete from a level playing field. That's all I have to say on this bill. Madam Speaker, I yield and ask for your favorable consideration.
The gentleman has yielded the well. For what purpose does Representative Abrams rise? She waives. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of the bill. The yeas were 110, the nays were 59. The bill, having received the requisite constitutional majority, is therefore passed.
Clerk will read the caption to House Bill 297. House Bill 297.
House Bill 297, Representative Buckner on 137. Bill to be entitled Act Amendment Code Section 50-3-54 relating to the state wildflower so as to designate the native azalea as a state wildflower. Bill has been for the House Committee on Agriculture and Consumer Affairs. The committee recommends the bill to pass. The bill is being read today for the third time.
Chair recognizes Representative Buckner to present the bill. Representative Buckner.
Thank you, Mr. Speaker. And I am so delighted that this bill has not got limited debate. This bill is actually only changing one word in the code. In 1979, the bill was passed to create a state wildflower. This is not to change our state flower, which is still the Cherokee rose. But back in '79, they wanted to have a state wildflower, and a lot of us call them wild honeysuckles, but the real term for them is native azalea. Somewhere along the way, the word native was removed from the code section, and there's a difference between azaleas and native azaleas. So we need to put the word native back in the law. That is all this bill does, and I would ask for your favorable consideration. If there are any questions, I'll be glad to yield, Mr. Speaker.
You have questions if you care to yield.
No. I'll take two.
Chair recognizes for a question Representative Gardner to your left.
Thank you very much, Mr. Speaker. Isn't that true that native azaleas are your favorite flower?
That's true. I do love them.
And is it a coincidence that you get to take this bill to the House of Representatives on your very own birthday?
Yes, ma'am. That's true. So it'd be a really nice birthday gift if you'd all vote yes. With that, Mr. Speaker, may I change my mind?
That was the Rules Committee's present to you, right?
Thank you. Thank you. I yield.
Lady yields the will.
Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 297 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Why don't we go ahead and recognize Representative Buckner on her birthday while we're voting for her bill. Happy birthday, Representative Buckner. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the passage of House Bill 297, the ayes are 172, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 229. House Bill 229.
House Bill 229 by Representative Teasley of the 37th. The bill being entitled Act Amendment Title 33 relating to authorization, general requirements for transaction of insurance, so as to provide for removing the insurer annual publication requirement, provide that the Commissioner shall provide on the Department's website a financial summary position of each insurer, to provide for changes for submission of reports by property and casualty insurers. Bill having been for the House Committee on Insurance. Committee recommends the bill do pass by way of a committee substitute. The bill is being read today for its third time.
Chair recognizes Representative Teasley to present the bill. Representative Teasley.
Thank you, Mr. Speaker. And considering that I am all that stands between you and adjournment, I will be as brief as possible. House Bill 229 is brought by the Department of Insurance. Basically, the meat of the bill is on lines 11 and 12, that currently insurance providers are required to, on an additional annual report, show volume and experience for specific lines of insurance that are written here in the state. And this is separate from the annual report that they are required to file, so the Department of Insurance feels that this is a duplicative measure and are asking that we remove this requirement. Part of the reason why is because over the 20-some years that this has been required, there has never been, to the Department's recollection, an open records request for these, and so they feel that this is a duplicative process that is an undue burden on insurance companies. So with that, I yield for any questions or be glad to yield the well.
You don't appear to have any questions.
I yield the well.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 229 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 229. The ayes are 170, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. The chair postpones until the next legislative day House Bill 287. House Bill 287. What purpose does Chairman Sims rise?
Mr. Speaker, wish to make a motion.
State your motion.
House rules be suspended so several general population repeal bills can be read this first time.
Clerk will read the captions.
Bill by Representative Sims, 169. Bill to be entitled Act Amending Code Section 20-8-1 relating to definitions relative to campus police officers so as to repeal a portion of a definition based upon a population classification.
On the motion of the gentleman,
Another bill by Representative Sims, 169, bill to be entitled Act provide that in counties of 500,000 more population according to the United States Census of 1960, any future United States Census, the Pension Board of Education of the county shall recompute the pension paid to teachers' employees. Another bill by Representative Sims, 169, bill to be entitled Act Amending Code Section 36-1511 relating to receipt, disbursement of funds for county law libraries and counties having a population of $950,000 or more. Another bill by Representative Sims, 169, bill to be entitled Act Amending Code Section 20-2-51 relating to election of Board of Education members, persons ineligible to be members or superintendent ineligibility for local boards of education so as to repeal a population provision prohibiting certain members of the county boards of education from holding other offices. Bill by Representative Sims, 169, bill to be entitled Act Amending Code Section 3132 relating to composition county boards of health to repeal a provision based upon a population relative to the superintendent largest municipal school system.
On the motion of Chairman Sims that the rules of this House be temporarily suspended to allow these population acts to be read for the first time and assigned to committee, is there objection? The chair hears none. It is so ordered, and each of those measures are assigned to the Intergovernmental Coordination Committee. What purpose does Chairman Dempsey rise?
Thank you, Mr. Speaker. I have two requests. The first is to ask for House Bill 511 to be moved from the Insurance to the Health and Human Services Committee, and both chairmen have agreed to that.
Clerk will read the caption.
House Bill 511 by Representative Dempsey of the 13th. Bill to be entitled Act Amendment Title 45 relating to state employees' health insurance plans, so as to provide for a pilot program, provide coverage for bariatric surgical procedures for the treatment and management of obesity and related conditions.
On the motion of the lady that House Bill 511 be withdrawn from the Insurance Committee and committed to the Health and Human Services Committee, is there objection? Chair hears no objection. It is so ordered. What purpose does Chairman Dempsey rise?
To ask that the rules be suspended and
Is this a motion?
Yes, a motion to ask that the rules be suspended and a resolution read for the first time and assigned to committee.
Clerk will read the caption.
Resolution by Representative Dempsey of the 13th. Resolution directing the Department of Community Health to collect and report certain data relating to bariatric surgical procedures.
On the motion of the lady, that the rules of this House be temporarily suspended to allow a bill to be read for the first time and assigned to committee. Is there objection? The chair hears none. It is so ordered. Health and Human Services. What purpose does the Speaker Pro Tem rise?
Make a motion, Mr. Speaker.
State your motion.
Move that rules be suspended and a bill be read for the first time and assigned to committee.
Clerk will read the caption.
Bill by Representative Jones, 47th. The bill will be entitled Act Amendment Act providing homestead exemption, Fulton County ad valorem taxes for county purposes.
On the motion of the lady that the rules of this House be temporarily suspended to allow a bill to be read for the first time and assigned to committee, is there objection? The chair hears none. It is so ordered. Intergovernmental coordination. What purpose does Chairman Weldon rise?
Mr. Speaker, I make a motion to have House Bill 520 withdrawn from the Ways and Means Committee and reassigned to the Judiciary Committee. I've spoken with both chairmen and they're in agreement.
Clerk will read the caption.
House Bill 520 by Representative Weldon of the 3rd. A bill to be entitled Act Amendment Code Section 48A89 relating to distribution use of proceeds, certificates specifying percentage of proceeds, each political subdivision, determination of proceeds for absent municipalities, procedure for filing for certificates, effect of failure to file.
On the motion of the chairman that House Bill 520 be withdrawn from the Ways and Means Committee and committed to the Judiciary Committee, is there objection? Chair hears none, and it is so ordered. Chair recognizes Representative Peak for a motion. Just a minute, Representative, if you'd step out, please. This House will be in order. We're still doing business. Chair recognizes Representative Peak for a motion.
Thank you, Mr. Speaker. I would like to ask the House to agree to House Bill 266 as amended by the House.
You want to restate that motion?
Only takes. I went to Auburn.
You don't have to remind us every day.
Mr. Speaker, I would like to ask, let's see if I can get this right, that the House would agree to HB 266 to the Senate substitute as amended by the House.
The gentleman has moved that this House agree to the Senate substitute to House Bill 266 as amended by this House. The clerk will read the caption.
You have 3 documents on your desk. The first document is the House substitute passed by this body to House Bill 266. The next document is the Senate Finance Committee substitute which is House Bill 266, as passed by the Senate. Upper right-hand corner, LC 286655S. The next document, Representative O'Neill, the 146th, Representative Peake, the 141st, off the following amendment. Amend House Bill 266, the substitute I just read, the Senate substitute, LC 286655S. The amendment is printed and placed on your desk, upper right-hand corner, AM 281231.
Should be on all. Chair recognizes Representative Peake to explain the Senate substitute and the House amendment.
Mr. Speaker, with your permission, I would like to yield my time to Leader O'Neill, since he graduated from the University of Georgia, a little smarter than I am, to explain the amendment.
A brilliant move, and the chair will concur, and the chair recognizes the majority leader of the House to explain the motion of the gentleman.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, we have under consideration the Senate substitute to House Bill 266 and a House amendment which now should be on everyone's desk. I encourage you to adopt this amendment so that Georgians don't have to wait on us to act any longer. Here's what Georgians are waiting on right now. Accountants all across the state are waiting on the General Assembly to act with our annual Internal Revenue Code update legislation in order just to file their tax returns. Businesses across the state desperately need some clarity regarding research and development tax credits, which are conditioned upon our compliance with the IRC. House Bill 266 now contains most of the provisions that this House passed long ago in House Bill 80. The TAVT update bill, which is the tax and tag and title bill, which includes the refinements worked on all summer and fall regarding our new motor vehicle tag and tax title law, which I remind you eliminated the birthday tax. Now, House Bill 266 also eliminates double tax potential on car lease transactions that came from our studies this summer, allows automobile dealers a more reasonable amount of time to collect and remit the title fees, reduces the tag title fee on rental car transactions, and clarifies that all trade-ins are credited against the computation of title tax regardless of whether it is a new or used transaction. We carefully coordinated our efforts over the summer and fall with all stakeholders, including tax commissioners, auto dealers, the Department of Revenue, and many others working toward the March 1st effective date. We approached this effort carefully and thoughtfully, fully weighing the impact of these changes on all stakeholders who came forth. Now all efforts are held up based on a new provision regarding how we define buy here, pay here dealers. This new language needs more vetting, especially since we have already discovered issues with buy here, pay here language that was crafted in a very hurry-up fashion. The buy here, pay here provision was never possible anyway to go into effect before July 1st, so it has no immediate impact like the provisions of the bill I've already mentioned that Georgians demand immediate action upon. This amendment I am proposing simply removes buy here, pay here from the bill. The only part that has hit turbulence and allows us to settle on the issues we have already reached agreement. I encourage you to vote yes and let Georgia businesses start to grow again. Mr. Speaker, I'll be happy to yield any questions. Otherwise, I urge your favorable consideration of the amendment and also the motion to agree as amended by the House on Senate Substitute 266.
You have a couple of questions. Do you yield?
I do.
Chair recognizes the minority leader of the House to your left for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Mr. Leader, is it not true that the changes referenced in AM 281231 would remove the concerns raised across the hall in the Senate by some of our colleagues regarding the predatory lending piece, which would have allowed buy here, pay here entities to charge basically to pay their tax on the lower book value, but to require those purchasing the vehicles to pay the tax on the higher market value.
Among many other things, it would have that impact for the time being. Yes, ma'am.
Thank you, sir.
Chair recognizes Chairman Rogers to your right for a question.
To my friend in the well, will you yield?
Yes, sir, I do.
Over the weekend, is it not true, I got emails from our county commissioners. The Senate version was going to be a large tax cut. Is this still the issue?
It's one of the many issues. That's certainly one. But there are others, and what's really kind of confusing about tax title law is revenue impact and whether or not it's a tax cut or a tax increase in the context of 386, which we passed over a year ago, gets very complicated.
Okay, will you further yield?
I do.
Our county claims it's going to be millions of dollars. Has ACCG blessed this amendment? I mean, that's where all the negativity is coming from. Is it not true?
They, I don't know that they blessed the amendment per se, but they certainly opposed the language that was in the Senate substitute to House Bill 266 regarding the buy here, pay here provisions. Yes, sir.
So if you'll yield one more time, is it not true we're going to amend House Bill 266 and agree to the Senate substitute and send it back to the Senate, then hopefully a committee of conference can work out the differences?
That certainly would be one favorable outcome, we'd hope.
Thank you.
Mr. Speaker, if there are no other questions, I urge everybody.
You do have other questions, but it's up to you whether you wish to yield.
I'll be happy to yield to another one or two.
Chair recognizes the Dean of the House of Representatives, Representative Smyrie, to your left for a question.
I think the minority leader has cleared me up, but I want to make sure that this is a House amendment to the Senate substitute, which clears up a lot of the problems we had.
That's what we tried to say the first time, and you're indeed right. It is a House amendment to the Senate.
I just want to make sure abundantly clear.
It took a Georgia-Auburn connection to do that, but we got it now.
Do you yield for any further questions?
Well, I think everybody understands what the proposition is before them, and I urge us to get on, let people in Georgia have some certainty about their business propositions, and let's move on and do our job here as legislators. Mr. Speaker, I yield the will.
Gentleman has yielded the will. Is there objection to the adoption of the House amendment to the Senate substitute to House Bill 266? Chair hears none, and the amendment is adopted. On the gentleman's motion that this House agree to the Senate substitute to House Bill 266 as amended by the House, all those in favor of the motion will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? Have all members now voted? If so, the clerk will lock the machines. On the adoption of the motion by the gentleman that this House agree to the Senate substitute to House Bill 266 as amended by this House, the ayes are 170, the nays are 0. This House has agreed. What purpose does Representative Peake rise?
Mr. Speaker, I move to move the
promise I hadn't been drinking.
They don't teach this over at Auburn, do they?
They don't. It's a little too complicated for us Auburn folk. Mr. Speaker, I move that we immediately transmit HB 266 to the Senate.
On the motion of the gentleman that the House agreement to the Senate substitute, House Bill 266 as amended by this House be immediately transmitted to the other legislative body. Is there objection? Chair hears none, and it is immediately transmitted. Page photographs will be taken at the rostrum immediately upon adjournment. We have a number of announcements. House will continue to be in order. You may want to hear the announcements. If you have an announcement, make your way down to the front of the chamber. Chair recognizes Chairman Maxwell for an announcement.
Thank you, Mr. Speaker. Ladies and gentlemen, Regulated Industries will meet hopefully in about 30 minutes in room 403. That's a change from our scheduled meeting room. We've moved it to 403. There's another meeting going on in our room, and they may not be through in about 35 minutes. So approximately 30 minutes, 403, Regulated Industries. Thank you, Mr. Speaker.
Chair recognizes Chairman Cooper for an announcement. Chairman Cooper.
Thank you, Mr. Speaker. Health and Human Services will meet immediately upon adjournment in room 606 of the LOB. If you will come quickly, we are taking up 2 small bills, and we will get you on your way to the governor's mansion. We don't want to keep the governor and Mrs. Deal waiting. Thank you.
Chair recognizes Chairman Carter for an announcement. Chairman Carter.
Thank you, Mr. Speaker. Appropriations Committee, we are meeting the full committee immediately upon adjournment in 341. Full committee appropriations, 341 today, immediately upon adjournment. Thank you.
Chair recognizes Chairman Battles for an announcement.
Thank you, Mr. Speaker. Retirement Committee will meet in room 415 immediately upon adjournment. We have 2 bills to take up. Thank you.
Chair recognizes Chairman Alan Powell for an announcement.
Thank you, Mr. Speaker. Just a reminder to the members of the Public Safety Homeland Security Committee. You have a committee meeting 30 minutes after adjournment, and I would advise you to please make every attempt to be there. We're going to be hearing some Second Amendment issues, and there will be a vote taken today. Thank you.
Chair recognizes Chairman Carter for an announcement.
Governmental Affairs Full Committee in the morning, 8 a.m. in room CLOB 606. Thank you.
Chair recognizes Chairman Morris for an announcement.
Thank you, Mr. Speaker. The House Banks and Banking Committee will meet immediately upon adjournment in room 506. We will be taking a vote on House Bill 465. That's 506 in the Coverdale building. Thank you.
Chair recognizes Chairman Weldon for an announcement.
Thank you, Mr. Speaker. Immediately upon adjournment, the Juvenile Justice Committee will meet in room 406, Coverdale Legislative Office Building. That's immediately upon adjournment. Thank you.
Chair recognizes Chairman Martin for an announcement. Chairman Martin.
Mr. Chairman, the Utilities Subcommittee of Chairman Parsons' Energy, Utilities, and Telecom had a meeting scheduled for 2 o'clock today. We were going to try to get that in, but with the appropriations notice in the other committees, we are going to delay that meeting. That subcommittee meeting will be in 606 CLOB at 8 o'clock tomorrow morning. We will hear House Bill 267 at 8 o'clock tomorrow morning, CLOB 606.
I don't know why it takes all 3 of them, but the governor's floor leaders are recognized for an announcement. Leader Hatchett, Leader Nimmer, and Leader Coomer.
We're going to sing. Okay, y'all ready?
Turn the microphone off. Turn the microphone off.
we would like to remind everyone that you are invited by Governor Deal and Mrs. Deal to a reception from 5:30 to 7 tonight at the Governor's Mansion.
That appears to complete the announcements as we wind our way to the finish of Legislative Day 28. Legislative Day 28. Chair recognizes the Majority Leader, the gentleman from Houston County, for a motion.
Thank you, Mr. Speaker. I move this House now stand in recess until 5 p.m. today, at which time we shall adjourn until 10 a.m. Tuesday morning, March 5th, 2013.
On the motion of the gentleman that this House be in recess until 5 o'clock p.m., at which time we would then adjourn until 10 o'clock a.m. tomorrow, March the 5th. All those in favor of the motion will say aye. Those opposed will say no. The ayes have it. This House will be in recess until 5 o'clock p.m. Then we'll stand adjourned until 10 o'clock a.m. tomorrow morning.